to suggest that someone as qualified and respected as Merrick Garland doesn't even deserve a hearing, let alone an up or down vote, to join an institution as important as our Supreme Court, when 2/3 of Americans believe otherwise, that would be unprecedented.
All right, ladies and gentlemen, joining us now to weigh in on this whole Supreme Court issue is Michael Mukasey, former United States Attorney General and former Chief Judge for the U.S. District Court. Hello, sir.
Hi. How are you?
Good to talk to you as always, Mr. Attorney General. Okay, so, you know, to me, for the president to stand there, a man who voted to filibuster Samuel Alito, even though he said he was qualified, a man who voted against Roberts, even though he said he was qualified, the hypocrisy knows no bounds.
Well, the historical inaccuracy also knows no bounds because it is, in fact, precedented. It happened at least 3 times in the 19th century that a nomination of somebody qualified, was disregarded by the Senate. And in fact, it not only is it precedented, but that's actually the way the founders planned it. Back at the time of the Constitutional Convention in 1787, there was a proposal put forward by a delegate from Massachusetts who modeled this on the Massachusetts Constitution, that any nominee who required confirmation or by the Senate, the president could nominate, and the Senate had to confirm by a majority vote. And no less an eminence than one of the authors of the Federalist Papers said that he felt that actually it should require an up or down vote within a limited number of days, and that if they didn't get it, then the nominee would go forward. That was James Madison. That proposal was voted down.
Interesting, very interesting. So you know, when then there's the Biden rule, of course, and if you want to look at everything, there's what Biden did to.
Well, you have to go from James Madison to Biden.
I know.
Really to go from the sublime to the ridiculous.
Yes.
Ahead.
But the Biden rule, where Biden himself said something very similar to what McConnell is now saying,
right.
And of course what Biden did to Bork and what Kennedy and Biden did to Clarence Thomas. I mean, they have this long history, and they just expect now everyone to forget it on the Republican side.
And what they did to Miguel Estrada, who was wonderfully qualified and who was subject to a filibuster because he was too qualified. They thought it would be dangerous if he got on the D.C. circuit, and then he would be in line for the Supreme Court.
Yeah, all right, so let me ask you this. Here's something else that concerns me, and something that was discussed at the time of the death of Justice Scalia. I haven't heard it talked about, but I don't think that the Republicans can trust Barack Obama. I know they're on recess now, I believe. I don't think he would do anything now unless he comes back on the last day of the recess next week and says, it's apparent they're not going to do anything, so I appoint Judge Garland to the Supreme Court. But let's say he doesn't do it in the next 2 weeks. Do they have to stay in session in January to prevent him from making this appointment on a recess basis?
Yes, they can stay in a sort of nominal session where they transact minimal business. Basically, 2 people meet and adjourn.
Yeah.
And it's my understanding that they're keeping a weather eye out for that.
Yeah, well, that's good, yeah. Now, let me ask you another strategy point here that's been discussed. If Hillary wins the election, God forbid, which assumes a lot, but let's say she wins the election, then the Republicans give Merrick Garland his hearing and his up or down vote after November, and they approve him. Would you suggest they do that if that were the case?
Look, that's a political decision for them to make. It seems to me, though, the question is they balance somebody like Merrick Garland, a person of high quality and great stature, against the possible nominee of a President Clinton, and they strike the balance and figure out which course they think is preferable.
As far as having 8 members on the court going forward until further notice, is that problematic to you at all? I know there's nothing in the Constitution, despite what many people think, that says it has to be an odd number or even 9 or anything like that. But do you think it's problematic at all?
Well, the only problem that it causes is in cases where the justices are evenly divided. They can then do one of 2 things. They can either affirm the decision that's being appealed by an equally divided court, which means that the decision stands for the parties,
Right.
but the underlying issue is not resolved, and that case has no precedential value. Or else, the Chief Justice can put it over to the next term and re-argue it when the court is up to its full complement of 9 justices.
Yeah, and very quickly, 10 seconds. Should Scalia's votes count if he made the votes before his death?
I think that it requires not only a vote, but also joining in an opinion.
Okay.
It's not just a vote.
Gotcha.
So the short answer is
Probably
if it's
not,
just a vote,
yeah.
no.
Mr. Attorney General, always a pleasure to speak to you, sir. Thank you very much.
Great to talk to you.
All right, thank you. Up next, folks, Gimme 5. Don't go away.